Well, thank you, Dean Budd, for those very kind words. And to our graduating students, congratulations. You did it. It's a major accomplishment. To your families and friends, know they couldn't have done it without you. And to our distinguished faculty, administration, and staff, I know you feel the same way as I do in being thrilled to be part of this amazing commencement. So I've been tasked with sharing some advice as you leave law school and enter the next phase of your life. I'll get right to the point. My first piece of advice should be obvious. Do not deflate footballs. But my second piece of advice may be more important. Do not falsely accuse others of deflating footballs. I mentioned deflating footballs not just to conveniently tap into the national crisis known as Deflategate, though that is part of it, to be sure. No, I say it mainly to remind you that you should never forget and you should never ignore what you've learned here. Because what you've learned here is incredibly relevant to all sorts of things, like trying to unravel bizarre sports controversies that we never would have known about before. But maybe more importantly, other things that affect who you are and that will affect your future as a lawyer. Think about it. When you started here at UNH Law, you've learned, since you started here, I should say, you've learned about major topics that provide the basis for law in the United States. Big ticket, often complicated topics like evidence and constitutional law and administrative procedure. Those of you who have studied intellectual property law have learned about patents and copyrights and how the law can protect innovation and safeguard ideas. The future prosecutors and public defenders in here can talk about all the criminal laws needed to convict the guilty and the criminal procedures essential to safeguard the innocent from being wrongfully convicted. The future business attorneys here are certainly competent now in negotiating a contract and signing it. I could go on and on. No matter what you studied, no matter which professors you took, no matter your grades, you've learned an incredible amount of information over these last 3 years. But maybe more important than what you learned is that law school has changed the way you think. And that change is permanent. There's no walking back from it. You may not realize how different you think about things, but you will. You'll approach new information from a very different lens than before you started law school. And think about it. You're probably now a lot slower to judge others than you were before you started school. You're probably more likely to help out two persons who are in a disagreement, figure out where their common ground is, and then help them. And you're undoubtedly learned that being polite and measured in conversation is a lot more persuasive than the loudest of yells and the sharpest of critiques. And I suspect you're more likely to care that there's a fair, predictable process in place before any punishment is levied. You're probably more troubled than ever by swift justice and unforgiving rhetoric. You probably find it harder to blame only one person when you know that there are often many causes for why something doesn't go right. You knew the world was complicated before you started law school. Now you have a better understanding of why. But even more importantly, you've learned that law is hard. It's not always mechanical. It's not always predictable. And it's not always right. You realize that there are many shades of gray, even more than 50, in the meaning of law. You've learned that looking up the law is often not that informative if you don't know what each word within the law means, or should mean, or could mean. It doesn't tell you the context or the ideals behind the law. It doesn't tell you about the struggles that may have gone into making that law a reality. And sure, nowadays anyone can Google the law. And yes, anyone can tweet it out. But not everyone can apply the law. Not everyone can explain what it means. You can. And that is truly a learned professional skill. It's part of what makes being a lawyer so rewarding. For the rest of your career, you'll work in an occupation where your brain and your work ethic and your judgment and your compassion will guide you. And that is true even if other people find you a little bit annoying when you talk about things like due process and actual evidence. Don't worry if people grow impatient with you. It's worth the wait. And that brings me back to deflated footballs. or would-be deflated footballs. The story of Deflategate, when viewed from the lens of an attorney, is very different from viewed from the lens of a mere sports fan. By now, you surely know that the New England Patriots and its star quarterback, Tom Brady, have been accused of an alleged scheme to keep footballs at a level of air pressure slightly below what is permissible in an NFL game, and they have been harshly punished. It sounds like a sports story. It is a sports story. But it can also be an exercise to show why attorneys watching something happening perceive things differently, and I would argue much more informed. An attorney, for instance, cares that punishment fits the crime. So an attorney will question why Tom Brady has been suspended for a quarter of a season and why the Patriots have been fined $1 million, even though the NFL Constitution only talks about a fine up to $500,000. Not sure where $1 million is from. And the Patriots are also required to lose multiple draft picks. Yet the NFL's own rules indicate that the underlying offense, having game balls be below air pressure, carries a $25,000 fine. Where do you go from $25,000 to $1 million? Where do you go from that to a 4-game suspension? Consistency counts to an attorney. An attorney also cares that Tom Brady is a member of a union, the National Football League Players Association, and thus has certain rights and obligations through a collective bargaining agreement that his union negotiated. He has a right, for instance, to contend that the league's power to see him punished shouldn't have been delegated by the commissioner to somebody else. Why? Because there's nothing in the collective bargaining agreement that talks about it. That matters. You can't make rules up as they go just to fit a set of facts. Brady also has a right to privacy in terms of his personal belongings, like his cell phone. Despite what the NFL seems to think, an employer can't grab your personal phone and all the data on it. It doesn't work that way. It's your phone. Brady, moreover, has a collectively bargained right to appeal his suspension in the form of arbitration. And he has a right to object to a potential witness being the arbitrator in that hearing. You never hear about a judge and the witness being the same person. There's a reason for that. An attorney sees these things and understands their importance in terms of the law. A fan doesn't. Brady's legal rights are also very different from those of the Patriots and their owner, Robert Kraft. Mr. Kraft owns a business, but it's not just any business, and it's not fully his. The Patriots are a franchise in a private association of businesses, the National Football League. They're in a joint venture to play competitive football. When you buy a franchise in the NFL, just like you buy a franchise in any other business, you often agree contractually to accept the authority of the association and not to sue the association and other owners of franchises. These contracts are very relevant to the Patriots because they make it extremely difficult for the Patriots to sue the NFL. An attorney realizes that, accepts it, and builds a strategy based on the constraints. An attorney also cares about so-called evidence used to implicate someone else. The NFL said it assembled an independent investigation. I don't know what the word independent means if you hire somebody to do something and you develop an attorney-client relationship with that person. That doesn't sound like independent to me. Independent sounds like it should be independent. Similarly, an attorney will care that a law firm that ran the investigation has no subpoena power. What does that mean? It means it can't get everything. It means it can't compel somebody to testify. Speaking of testify, they didn't testify. That's been it's a verb used by many in the media. It's wrong. They weren't speaking under oath. There's no threat of perjury. Use the word testify as it actually means. An attorney will also care that the report omitted evidence and witness statements. That matters. It matters in law, it matters in football, it matters in life. You know, I could do the same approach to any news story that you've seen lately. And the point isn't news analysis. It's analysis of the world around you, the things that you see. You know, law school is like a form of LASIK. After law school, you see things a lot more clearly, and you pick up things that you didn't before. Embrace it, and you will thrive, and congratulations to the class of 2015. Thank you.